everyone, it's Manon Durand. I'm a lawyer in Pharmaspecific, and today we meet for a webinar dedicated to the 10 classic errors of promoter and CROs when reimbursing patients in France. So let's start with a little presentation. So we're Pharmaspecific. We're here for 10 years. We are a CRO ISO 9001 certified, and we have a patient reimbursement service. We also have the Blog de la Recherche Clinique, which is a web journal of information in clinical research, and we have 6,000 subscribers. And we also have a website of online training, coaching, counseling, events in clinical research, and career and regulatory. I am Manon Durand. I'm a health lawyer and clinical research specialist, and also personal data specialist. And I'm a collaborator at Pharmaspecific for 1 year. So let's start with a summary. We'll first see the background and definition of the patient reimbursement. Then we'll see textual references in a part 2. In a part 3, we'll see the 10 mistakes of promoters and CROs. And to finish, we'll see part 4, conclusions with tables. So first part, background and definition. Reimbursement of patient expenses is a process that occurs in the context of research involving humans. During this research, participants will incur expenses related to their participation in the study, such as transportation costs to the various sites and accommodation costs. However, it is expected that the participant will not be financially harmed by his or her participation in the research. Therefore, all expenses incurred by the participant must be reimbursed. That's why reimbursement is an obligation. So patient reimbursement is the process by which a company, so the study sponsor or its subcontractor, for example, CRO, and most likely the CRO or a subcontractor because the sponsor cannot have access to identifying data. So a company will reimburses the participant, so patient, for the cost of participation based on various financial documents, invoices, for example. The objective is that the patient does not feel any financial consequences related to his participation in the study. For example, if a patient is living in Bordeaux and has to travel to Paris for a research project and has to stay in a hotel, she or he will be reimbursed for transportation costs, so plane, train, or car, accommodation costs for the hotel, and food costs. So part 2, let's see what are the textual references to the reimbursement of patient expenses. First of all, we have Article 16.6 of the Civil Code, which provides that no remuneration may be paid to a person who lends himself to an experiment on his person, to the removal of elements of his body, or to collection of its product. This principle exists in order to avoid abuses that will lead to the commodification of the human body, for example, to use it as a means to obtain income. For example, by participating in several clinical studies for the sole purpose of being paid. So this is the main principle. But however, we have Article L 1121.11 of the Public Health Code that states that research involving the human person does not give rise to any direct or indirect financial compensation for the persons who take part in it, apart from the reimbursement of expenses incurred and, where appropriate, compensation of constraints suffered paid by the sponsor. Thus, the principle as follows is as follows: the participant in research involving the human person may not receive any financial compensation. So that's what we saw with the Article 16.6 of the Civil Code, except reimbursement for expenses incurred and compensation in the event of constraints. So what's the difference between those two methods? So um, reimbursement of expenses refers to the payment of additional costs related to the research. So that's what we talk about, the transportation, the accommodation, etc. And on the other hand, the indemnity compensates for any constraints that may be linked to the participation in the research. For example, time constraint, arduousness, etc. It should be noted that a decree has just set the maximal annual amount that a research participant can receive as compensation at 4,500 euros. There's no limit for the reimbursement of expenses, but this limit applies for the constraint. The Good Clinical Practices (GCP) also refer to the reimbursement of costs to patients. First, the French GCP said that the sponsor does not pay any direct or indirect financial compensation to the person who take part in the trial, apart from the reimbursement of expenses incurred and, where applicable, compensation for constraints suffered in accordance with the provisions of Article L112111 of the Public Health Code. So that's basically a resay of the article of the Public Health Code. And then we have the ICH GCPs which say that when trial subjects receive compensation, the method and manner of compensation should comply with applicable regulatory requirements. So we refer to to the article L112111 of the Public Health Code. Finally, the CNIL's reference methodologies, which are texts put in place in the context of health research, allowing sponsors to be exempted from requesting authorization for their data processing from the CNIL, also mention the reimbursement of expenses. First, in the paragraph 2.2.3, the only categories of personal data relating to person undergoing research that may be processed are the following. So there are many categories. And reimbursement of costs incurred by the person concerned related to the research. And then we have paragraph 2.3.2 that said subcontractors acting on behalf of the data controller and not having the status of a research site may be recipients of administrative data identifying the persons taking part in the research in strict compliance with the following cumulative conditions. So there's condition, and then there's access to personal data is for the purpose of reimbursing the costs of transporting person and or paying allowances or etc. So we just saw there is four sources. We have the Civil Code, the Public Health Code, reference methodologies, and good clinical practices. All lead to the reimbursement of patient costs. However, we don't have a lot of rules that are detailed, etc. But we'll saw with the next part, what are the rules that you must apply. So let's go on the 10 errors of sponsors and CROs in reimbursement. The first error is to let one person handle both the clinical study and the reimbursement. When providing reimbursement, it should not be possible to associate a patient with the condition. However, a person in charge of the clinical study could have had access to the protocol and therefore to the inclusion criteria and could identify the pathology of the patient. The true services should therefore be clearly distinct and performed by different entities. Uh, you can refer to the paragraph 4.14.1 of the GCP. So that's the first error not to make. You have to make sure that two different entities will take care on the clinical of yes, on the clinical study on the first hand, and on the reimbursement on the other hand. The second error is letting an unlicensed provider handle reimbursement benefits. Not just anyone can perform the expense reimbursement function. The provider in charge of this mission must have the necessary skills to carry out this activity. Thus, the sponsor must be vigilant about the provider with whom it contracts for this service and ensure that the provider is familiar with all the rules applicable to the reimbursement process. So the sponsor must be sure that the provider that he uses is aware of all the rules applicable to reimbursement service. The third error is to make the reimbursement in a lump sum. The regulations in force do not specify the type of reimbursement allowed, actual or flat rates, but Article L112111 of the Public Health Code refers to expenses incurred and therefore justified for reimbursement on an actual basis, with the provision of supporting documents seems to be preferred by the law. Moreover, a flat rate reimbursement, so higher than the amount of expenses actually incurred by the person participating in research, could be requalified as a disguised compensatory allowance, which is prohibited. The fourth error is not to retrieve receipt for expenses. Any reimbursement of expenses to a patient in the context of his or her participation in a research involving the human person must be justified. In order to do so, the collection of supporting documents, for example invoices, mentioning the amount of expenses as well as the issuer of the receipt and the date of expense, is essential, in particular to be able to prove this to the sponsor that the sums reimbursed are indeed related to the research. So it is important for the sponsor, for that the sponsor could link the 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 expense to the research. The fifth error is to retain data indefinitely. There is no statutory requirement for the retention of patient reimbursement data. However, this does not mean that such data can be kept indefinitely. It is therefore necessary to define a reasonable retention period internally in order to respect both the purposes for which the data is retained, accounting, claims, legal action, etc., and the rules on the retention of personal data. So a balance should be made between the retention of personal data, which must be limited in time, and the obligations, uh, the obligation, the obligations, made by the law concerning those data. The sixth error is to retrieve data on the patient health status. While reimbursement allows the service to have access to the patient's identifying data, this does not mean that it can have access to all of the patient's data. Thus, the person in charge of reimbursement must refrain from collecting any data that is not necessary for the reimbursement service, and first and foremost, health data, which is sensitive data and cannot be available to anyone. The seventh error is transfer the patient's identifying data to the sponsor. We talked about it in the first part. During and after the research, the patient data sent to the sponsor must not show the names of the person concerned or their addresses or any other information that would allow direct identification. However, this is precisely the information used in the reimbursement process, so none of this data can therefore be transmitted to the sponsor. That's why the two activities have to be kept apart. The eighth error is not having read the applicable text. All applicable text to clinical research must be known and mastered by the personnel working on the reimbursement service, so JADE law, good clinical practices, orders, European regulation, and GDPR. This knowledge must necessarily involve reading the reference text, Simple knowledge through practical experience is not sufficient and may lead to omissions or misunderstanding. The ninth error is disregarding the principles of the GDPR. The GDPR applies to any company as long as it's located in European Union or processes the data of European citizens. Therefore, all of its principles must be taken into account in the framework of the reimbursement service. So information, legal basis, data security, data processing, type of data collected, implementation of the processing register, and impact assessment, standard contractual clauses if applicable, etc. All of those principles must be taken into account on this prestation. And the last error not to make is not sending the reimbursement form to the ethics committee. Although it's not strictly a requirement, it is strongly recommended that the cost reimbursement form or other means of collecting patient information be submitted to the EC at the time of submission. This will allow the EC to assess compliance with applicable regulations and will provide additional security for the performance of the service. Okay, now that we have see all of the principle, let's make a little conclusion. So we have a table with principles to be avoided and what we have to prefer. So the first principle to be avoided is that the same person handles both reimbursement and management of the same study. Uh, you need to make two separate entities in charge of these missions. One entity will be in charge of the management of the study, and the other entity will be in charge of the reimbursement. But the two are not possible. The second error not to make and to be avoided is that the provider who handles the reimbursement does not have the authority to do so. The chosen provider must be fully aware of the rule applicable to the service. So he must know how the service should be made, what are the rules, etc. The third error is a reimbursement that will be made on a lump sum basis, because the law seems to prefer a reimbursement made on an actual basis. The fourth error is to be avoided is supporting documents, uh, invoices, which are for expenses which are not provided. You must be sure that all the receipts allow to verify the veracity of the expense incurred are received. The fifth error is if the data is stored indefinitely. Uh, you have to prefer that a retention period for document is defined internally. The sixth error is when data on the patient health status is retrieved. No data on the patient health status must be retrieved for all the reasons that we saw. The seventh error is if patient identifying data are transferred to the sponsor. It can happen in any circumstances. No patient identifying data is transferred to the sponsor and must be. The eighth error is if the applicable texts are not read. All applicable regulations are read, understood, and respected by those involved in the reimbursement process, and it's an obligation that should be taken into account when you organize your reimbursement service. The ninth error is if the GDPR is ignored. Uh, Yet the GDPR is an integral part of the reimbursement and it's taken into account in the implementation of the service. And then the last error, if it's the data collection form is not sent to the EC. The ethics committee received the form and validated it, thus confirming the proper execution of the reimbursement. That's what have to be preferred because if the ethics committee validated the data collection form, then you have second degree of security. Let's take a last look on the references. So we have Article 16.6 of the Civil Code. Then we have Article L112111 of the Public Health Code. Then we have paragraph 5.8.3 of the Good Clinical Practices. And then we have paragraph 2.3.2 of the CNILS reference methodologies. Okay, so let's finish with a little presentation of our services. First, we have a reimbursement of patient expenses service. We take care of the organization and reimbursement of patient expenses related to travel, notably, in the context of their participation in your trial. So we take care of setting up the procedure and the reimbursement forms, of administrative management, and of monthly reporting. If you want more information, you can contact us or for a quote on contact at pharmaspecific.fr or at the number which is written. Then we have a legal watch service in order to stay informed of legislative and regulatory changes in the fields of clinical research and data protection. We have set up a monthly legal watch focusing on 4 points: research involving the human being, medical devices, transparency, and data protection. You'll see the rates below. So for individual and independent, it's €30 VAT included per month. And you can book it on pharmaspecifictraining.com. And for a team, you can contact us for a quote on contact at pharmaspecific.fr. We have also a service of legal advice. You can ask me a legal question about data protection or clinical research, and then you will get a telephone contact and a PDF summary note answering your question. You can book it on pharmaspecifictraining.com. And to finish, we have a DPO service because we know that all the obligations arising from the GDPR are unclear and time consuming, and that you don't know where to start maybe or how to answer your customer's question. Then you can contact us to provide you with a DPO service. You also can contact us for a quote on contact at pharmaspecific.fr. Thank you for your attention and see you very quickly for another webinar.